So last time, we talked about the procedure for re-registration of a public company as a private company. Now we're going to talk about the procedure to re-register a private company as a public company, as seen in section 56 of CAMA. Let's go. So the first thing you will do is to convene a board meeting approving the re-registration. Then the second thing you will do is to convene a general meeting, where you would pass a special resolution approving the registration. Note: in the previous video, I omitted the fact that the company would give a 21-day notice to members entitled to attend the meeting. Usually this is a standard for every general meeting, but still it's important to highlight. So if the company was a public company re-registering as a private company, not only would it give that 21 days notice, but it would put an additional notice of the general meeting in at least 2 national dailies. In this case, however, since it's a private company that wants to turn into a public company, the company secretary of this private company would just give a 21 days notice to the members entitled to attend. No need for the additional notice. Now back to the video. Now at the time the special resolution was passed, you have to ensure that the following requirements are met. 1. That the company has a share capital. 2. That the requirements of section 57 are met as regards share capital. 3. That the requirements of section 58 are met as regards to its net assets. 4. If section 59 applies and it involves recent allotment of shares for non-cash consideration, the requirements of that section are met. And 5. That the company has not previously been re-registered as an unlimited company. To have a full grasp and understanding of those conditions, I've made a separate video on them, and I highly recommend you check it out, as it's very essential to the procedures I'm stating here. So what I'll be doing here is just to list them out. At the time the special resolution is passed, ensure that the following requirements are met. 1. That the nominal value of the company's allotted share capital shall not be less than 2 million naira. 2. That not less than 1/4 of the allotted shares of the nominal value of the shares and the premium on it must have been paid up. 3. If any shares in the company or any premium on it has been fully or partly paid up by an undertaking given by any person that he or another should work or perform services, the undertaking shall have been performed or discharged. 4. If shares have been allotted as fully or partly paid up as to their nominal value or any premium on them otherwise than in cash, and the consideration for the allotment consists of or includes an undertaking to the company, the undertaking shall have been performed or discharged. 5. A company that is re-registering as a public company must not reduce its share capital, even if it is supported by a solvency statement, and the reduction should not make the nominal value of the company's allotted share capital to be below 2 million naira. 6. The company shall obtain the following: a balance sheet prepared as at a date not more than 7 months before the date on which the application is delivered to the Commission, that is CAC, an unqualified report by the company's auditors on the balance sheet, and a written statement by the company's auditors that in his opinion at the balance sheet date, the amount of the company's net assets was not less than the aggregate of its called up share capital and undistributable reserves. Now, between the date of the balance sheet and the date on which the application for re-registration is delivered to CAC, there shall be no change in the company's financial position that results in the amount of its net assets becoming less than the aggregate of its called up share capital and undistributable reserves. 7. Between the date of the balance sheet and the date on which the application for re-registration is delivered to CAC, there shall be no change in the company's financial position that results in the amount of its net assets becoming less than the aggregate of its called up share capital and undistributable reserves. Now, this application for re-registration must contain a statement of the company's proposed name on re-registration, and in the case of a company without a secretary, a statement of the company's proposed secretary. This application is to be delivered to CAC along with the following documents. 1. A copy of the special resolution that the company should re-register as a public company. 2. A copy of the company's memorandum and articles as altered. 3. A copy of the balance sheet and other documents. And 4. A statement of compliance that the requirements for re-registration as a public company have been complied with. If CAC is happy, CAC will re-register the company as a public company. CAC shall issue a certificate of incorporation as altered. The certificate shall state that it is issued on re-registration and the date on which it is issued. This certificate is prima facie evidence that the requirements of this act as to re-registration have been complied with. And that's all there is to it. The next procedure we're going to look at is re-registration from a private company limited by shares to an unlimited company. Thank you very much for watching my video. If you like what you just watched now, please like, subscribe, and share with your friends. Also, please feel free to hit the notification bell so that you get updates when my videos come out. Engaging with the content actually helps the algorithm see my videos, so I get to share it with more people. Don't worry, we'll be getting more content like this. Have a great day.